So it seems that I blinked and didn't make a video for like forever. So fortunately, nothing has been going on in this case. There have been no new developments that we've missed, nothing that's significant to report on. So we haven't really missed anything as a result of that. But I did want to follow up on my promise to you guys to talk a little bit about some of the strategic thinking that I see going on in this particular case. And my goal in this is to hopefully give you some guidance about just the way that lawyers think about these types of cases and these types of issues, and to hopefully be able to help you so that if you're navigating similar types of problems, it'll hopefully give you a little bit of perspective to get through that situation safely. So with that, let's talk about strategic thinking. So in general, to develop a strategy about really anything at all, you have to know what your objective is. Normally in a lawsuit, that's going to be pretty straightforward. You have person A suing person B. Both of them want to win. Both of them want their perspective to win. Person A wants person B to be found liable. Person B wants to be found not liable. So you develop your strategy based on that objective and what you're going to need to do to be able to achieve it. But with family law, it's a little bit different because there isn't really winning and losing. Okay, you're going to be divorced no matter what. So where it really can get a little bit sticky then is kind of defining what those objectives are. And that gets especially complicated when you're dealing with domestic violence situations, because it's often the case with abusers, because abuse is about control, that conflict itself is a means of achieving control over your victim. So in litigation, it's often not the outcome that drives the strategy of somebody with an abusive personality. It's the conflict itself is its own goal. So I want to point that out because I think it's important to see why, if at all possible, recognizing that early is a really, really critical part of being able to successfully navigate a high conflict family dispute like this. One of the earliest strategic decisions that was made in this case was the choice to pursue a collaborative divorce process rather than just going straight to contested litigation. So that indicates a couple of things in terms of the objectives. Typically, people pursue collaborative divorce because they want to be able to resolve things privately between themselves. They want to be able to do it amicably. They don't want to be in this adversarial, oppositional type of setting. But collaborative divorce has some pretty significant limitations as well. So if you aren't familiar with the process, it's essentially a way of just doing the divorce outside of the court and kind of going through it yourself to reach a mediated type of resolution that you then just go ahead and go to court to finalize. You don't have to go through this process of trying these things that you can't agree on. But if it doesn't work, then there's a lot of downsides to it, not just the, sunk cost of the lost time that you've spent, but often substantial financial resources. You can't use the same lawyer in collaborative divorce that you go on to use in litigation. You can't use the same experts, and you can't use any of the communications or, temporary agreements, whatever that you might have reached during that process. It all basically gets wiped clean when you go to litigation. So there's a very heavy investment in the collaborative process. And I think what comes with that potentially is a bit of sunk cost fallacy. You get so far into it that you're committed to seeing it through and finishing that way. And as a result, you might find it hard to recognize if it's not working well to the point that you really do need to pull out. It's very difficult to stop just continuing to invest in that process that you committed to initially. But The thing with collaborative divorce, though, is that it really presumes good faith intentions on both sides to actually reach a resolution in the case. And so, if you're dealing with domestic abuse, that may not be likely, not just because you have so much pattern of conflict and hostility and things like that already, but because the conflict itself is the goal. As soon as the divorce is resolved, then the fight is over. And an abuser doesn't want the fight to be over. The abuser wants the fight to go on and on and on. So abusers will keep abusing. That makes collaborative divorce typically an extremely bad fit for an abuse type of situation. Now, this was a decision that likely was made by Ioan and Alice themselves at the outset. We heard some kind of stuff about how they were conferring with lawyers and stuff before Ioan moved out of the house. So, they may have gotten advice before they made that decision, but it isn't a decision a lawyer made. It's a decision they made. And so that's one that I do suspect that probably in hindsight, at least on Ioan's part, there's probably some regret for how that has turned out. Not just because it did then, create a problem when it didn't work and you have to lawyer up, you got to start the whole process all over again from scratch. But also just because, I'm sure he was really hopeful that he was going to be able to make this type of collaborative relationship work. But clearly that did not happen. One of the big reasons why I think this was particularly damaging in this specific case is just because of the parental alienation component here. Most parental alienation experts, mental health experts who are dealing with this type of abuse, which it is considered to be a type of child abuse, will tell you that it's very important to intervene early, that it's much, much easier to nip it in the bud before it evolves it into something that's really damaging, really entrenched, and really difficult to, frankly, deprogram, for lack of a better word. So we don't know, for sure, of course, that collaborative divorce was a problem when it came to the parental alienation. But what we did see is that the signs of the parental alienation were there really from the beginning of these text messages and stuff that were admitted as evidence once we finally acknowledged this process is falling apart. And so because collaborative processes only work by agreement, they aren't a situation where you have an arbiter. If you don't agree on what somebody is doing or what's right or whatever, you don't have that decision maker to tell you how it's going to be. If you can't reach a decision yourself, then that just means you're done with the collaborative process. It's time to go to litigation now. So without having that sort of arbiter in place, there isn't really a good mechanism in collaborative proceedings to force a parent who is alienating the children to behave differently. There's no way to really address that issue without the consent of the person who's causing the problem. So that, to me, is a real potential just tragedy that resulted from probably an overly optimistic perspective on what the realistic range of outcomes of this dissolution was really going to be. I don't want to certainly blame Ioan, for wanting to hope for the best. But it just is unfortunate that I think in this particular case that may have clouded his perspective on the ruthlessness that maybe is going to be required to deal with these problems, and that maybe would have been the more appropriate strategy from the outset. When I look at Alice's decision making over the course of this case, God, once again, guys, it just reminds me so much of Amber Heard. And what I mean by that is that one of my kind of ongoing observations about Amber Heard is how she did not seem to be very good at this type of long-term thinking about the consequences of her actions. And that made it very difficult to have a consistent long-term strategy. When people are impulsive and they act out of anger and emotional types of impulses, then yeah, that's something that you're going to justify doing because you wanted to do it. It's not something that you plan to do ahead of time because it ultimately furthers the objective that you're trying to reach. So some examples of this that I see with Alice were, from the very outset, the collaborative divorce process, she doesn't seem to have foreseen the possibility that it could go south. I say this because we saw all of these text messages and emails and Our Family Wizard messages and stuff like that show her basically trying to, bully Ioan into giving her what she wants, threaten him, blackmail him, etc., etc. Not apparently recognizing how terribly incriminating and problematic those types of things were. It seems that she didn't foresee the possibility that her own words would be used against her. So another example of that is the way that she handled the TRO once the request was filed. Her initial response was to file this summary denial, right, where she basically says, I don't even know what the allegations are, but it doesn't matter because it couldn't have anything to do, it couldn't possibly meet this legal standard of being harassing or abusive or anything like that. Well, of course, lo and behold, there's 100, pages of exactly that. So I don't know if she forgot about them. Seems pretty unlikely. So surely she would know this is what it's based on. This is going to come to light. The judge is going to see all this. And this bare denial is not going to reflect well on my credibility. I think that's how, strategically minded people would think about a situation like that. You get hit with the restraining order application and you've screwed up. You're going to think a little bit differently about how to handle that. But that's not how she did it. And then continuing to make all of this noise publicly, of course, the short-term decision to, announce I'm going to be violating the TRO, clearly not very prudent from the standpoint of avoiding that finding of domestic violence. Choosing to simply not contest it at all, make a bunch of public statements about how, her side hasn't been heard yet. She's going to have her opportunity to present her side. Well, no, she isn't, okay? It is the law of the case. It has been litigated and decided. There is another issue we learned about from Depp versus Heard, this issue of collateral estoppel, right? It's the idea that you don't get a second bite at the apple on an issue that's been litigated. It was why Amber Heard argued that the UK judgment that Johnny Depp, the son got against Johnny Depp, she should be able to get the benefit of that so that he didn't get a second bite of the apple. Fairfax Court said, no, sorry, that wasn't your case. You weren't part of it. And so it's not a full and fair litigation as to the dispute between you and Johnny. But in this case, we had notice, we have the parties being involved, we had an opportunity to dispute the allegations, an opportunity that she chose not to take, but nevertheless was available to her through the process. And so as a result, whether or not her conduct, her sending all of these messages and so forth constituted domestic violence under California law, that's been decided. Court is not going back there, not going to be relitigated. It's done. It's time to move on. Now, it's also really clear that her lawyer gets that, okay? Because about the only thing that Alice has said in court since the domestic violence restraining order was filed is this comment that she made to the extent that, acknowledging, oh, I maybe didn't behave as well as I should have. I was just so very upset. So this is an effort at damage control by the lawyer. The lawyer knows we're not going to be able to relitigate this. We're stuck with it. You're not going to be able to continue to deny it and deny it and deny it. We need to accept it and find a way to move around it. So I see that in the lawyer's drafting of that declaration, that strategic guidance that perhaps Alice needs to be able to get through the case effectively, to basically recognize that, look, this continued insistence that everyone else is lying and everybody has it all wrong and there's all this evidence on your side and stuff like that, that is not going to work with the court. It's decided, time to move on, and we need to behave accordingly. I know people always like to know, what sort of advice would you be giving these people? Of course, there, again, so much going on behind the scenes that we don't know. So, a lot that you can't take into consideration that their actual lawyers are doing. But given what we've seen here, I'm willing to go ahead and tell you a little bit about how I would be advising these people. So first, Ioan. My advice to Ioan would be, you need to just sit tight as best as you can, prepare your case as best as you can, keep your eyes on the prize, and wait for Alice to fuck up. There's a lot of reasons for that. He doesn't have infinite money and resources. Very few of us do. And so in any lawsuit, not just this one, in any lawsuit, you're always dealing with trade-offs between what do you want to do and what can you afford to do. You can always hire another expert witness, spend more time on this research, that angle of attack, whatever. But, you have to prioritize when you have a budget to work with. And so getting through the trial is probably, the biggest concern from a cost perspective. Trials are very, very expensive. So you just don't want to blow your financial resources way ahead of the game by, trying to seek out interlocutory type of relief, temporary type of relief when there's a problem. Another common thing in every case is, the need to kind of frame the judge's perspective of you and your position. Courts in general are going to look more favorably on people that can solve their own problems than people who have to run to the judge to fix everything. Clearly, there's a lot of middle ground between those, but by and large, less is more when it comes to litigation and, kind of getting that perspective, that first impression with the judge that you want to be able to make. So if it isn't absolutely critical that you bring it to the judge right now, then don't bring it to the judge right now. Let it wait. See if you can solve it. Alice, as we've seen, does not seem to be able to self-regulate very well. So there's still a few months left before this trial. We've already had criminal charges come and go. There's just a pattern here of self-destructive type of behavior. I say this not in a schadenfreude type of sense, like, oh, sit back and then, laugh when she messes up, but just recognize that that is a potential resource that you have. When you have somebody who can't think strategically very well, they're going to make mistakes. And so those mistakes can work to your advantage. You just have to be patient and let them occur. For Alice, my advice is going to be, if you want custody of these children, you need to think long and hard about settling this case, because there is really very little potential for an upside at trial. Alice is coming from so far behind, as we've seen with that domestic violence finding, that the odds are really not good for her being able to walk out of a trial situation with custody at all, let alone the full custody that she is asking for, with Ioan just having visitation. If Ioan has full custody of the children, that means that Alice is responsible for child support. There's other issues going on in this dissolution as well that deal with property division, assets, and stuff like that. There is a prenuptial agreement, which, based on the statements she's made about it, Alice apparently believes it isn't fair, it's not enough, she should be getting more. Well, that type of thing can be negotiated in a settlement. But once you go to court, you're just going to get what the judge gives you. And so unless you've got a pretty strong argument to throw out that prenup, which, is a pretty limited range of circumstances, chances are you're going to be stuck with it. So that's really the golden opportunity for Alice to get what she wants out of this situation, assuming, we can know what she wants, that there is a thing that she wants, other than just for the marriage not to end. So like we said, the custody trial in this case is set for July. It's just a couple months down the road. And so at this point, it doesn't look like there's going to be any kind of material interlocutory action taken, things like temporary orders to try to, get the children removed or anything along those lines. It does not look likely. So unless something significant like that happens that gets our attention, chances are the next I'm going to be talking to you about this case is when we're closer to some kind of resolution, whether that's a voluntary resolution or, the case is going to go forward to trial. So I'm going to continue to keep an eye on it. Look forward to seeing your thoughts and your questions in the comments. And in the meantime, I will see you next time.